Okay, let's talk about one of the most maddening subjects in trademark law, and that is the law of dilution. And dilution law exists to do two things. It exists to protect the distinctiveness of a mark, and that is the sub-cause of action in the dilution statute known as blurring, and also the protection of a mark's reputation, and that is the sub-cause of action known as tarnishment. And so those two ideas are expressed in the federal dilution statute with the text, the owner of a famous mark that is distinctive inherently or through acquired distinctiveness shall be entitled to an injunction against another person who commences use of a mark or trade name in commerce that is likely to cause dilution by blurring or dilution by tarnishment of the famous mark, regardless of the presence or absence of actual or likely confusion. And so that's the key thing. This is a trademark cause of action that goes beyond likelihood of confusion and will allow a trademark holder to get relief even in the absence of a likelihood of confusion. So right away we notice, what kind of marks are we dealing with here? We're dealing with so-called famous marks. And so this is any famous mark. It doesn't matter if the distinctiveness is acquired or inherent. And so a famous descriptive mark, one that got protection because it has secondary meaning, is eligible for protection under the dilution statute. So what constitutes a famous mark? A mark is famous if it is widely recognized by the general consuming public of the United States. And there are multiple factors that go into this: advertising, sales, recognition, registration. Now, the trademark dilution statute, or at least the federal trademark dilution statute, was amended in the mid-aughts to clarify a debate that had existed initially under the law, whether or not you could get dilution protection for so-called niche fame. If you were famous in a particular area or in a particular kind of market, would you get dilution protection there? There was a divide in the courts, and so the amendments in the mid-decade kind of clarified famous means famous for the public at large. And so, is this sensible? One thing that it does is it constrains the cause of action. And given the vagueness of the dilution cause of action, as we'll discuss, that represents an important check. On the other hand, of course, we may wonder, insofar as we believe that dilution captures some kind of actual real harm that trademark law ought to go after, it's possibly the case that famous marks are actually more resistant to dilution than non-famous marks. And, but this is kind of a problem we'll be dealing with later on, that it's so hard to measure the cause of action or the harm that we're trying to police with dilution in the first place. And maybe it's the case that only famous marks are the target of, diluting activities. And so what makes for a famous mark in practice? Some marks that have been held to be famous. I have a list from McCarthy on the screen. Audi, America's team for the Dallas Cowboys, Apple iPhone, its trade dress, Motown for music and recordings, Nike, Pepsi, Rolex, Starbucks, and some marks now that have been held to be not famous. Things like the App Store, BioSafe, Coach. Maker's Mark's red wax dripping seal has been deemed not to be famous, as has the University of Texas Longhorn logo. So let's talk about the liability standard. And interestingly, prior to amendment, the Supreme Court had held that to have a cause of action for dilution, you need to prove that there has been actual dilution. Alleging that it is merely a likelihood is not good enough. And Congress responded to that Supreme Court ruling by amending the statute to say that a likelihood of dilution suffices. So, what exactly is dilution? It is not confusion. So what exactly are we going after here? And so the seminal law review article that kind of gave rise to the cause of action in the states prior to the eventual codification in federal law comes from Schechter, and he defined it as, quote, the gradual whittling away or dispersion of the identity and hold upon the public mind of the mark or name by its use on non-competing goods. And so this idea that we need to protect a mark's selling power is one that is certainly not uncontroversial. is that something that ought to belong to the trademark holder? And recall, we've had this discussion over the course of the term about the question about how powerful do we think brands ought to be. And so here we have a cause of action dedicated to the proposition that they should be powerful indeed. And so there's a comment from the restatement. Tarnishment and dilution of distinctiveness, although conceptually distinct, both undermine the selling power of a mark. The latter by disturbing and this, I love this part, the conditioned association of the mark. It sounds sort of Pavlovian, with a prior user, and the former by displacing positive with negative associations. Thus, tarnishment and dilution of distinctiveness reduce the value of the mark to the trademark holder. And of course, implicit in all this is the conclusion that that is something that federal law ought to do, or dilution law ought to do. And in this case, we have a federal statute that we're going to be focused on here. So let's start with the idea of dilution by blurring. And so what is blurring? And so under the statute, dilution by blurring is association arising from the similarity between the mark or trade name and famous mark that impairs the distinctiveness of the famous mark. So the famous mark doesn't do its job as well once it has fallen prey to blurring activities. But note that under the text, merely associating your mark with a famous mark ought not to be good enough, right? It's not association. It's association that actually impairs the distinctiveness of the famous mark. And so what could this possibly mean? Imagine we're in the car market and we have Rolls-Royce, Cadillac, Toyota, Chevy. And so Rolls-Royce is a distinct mark among the several kinds of sources of cars that one could possibly consider for purchase. And imagine now there's Rolls-Royce gum, Rolls-Royce paint, Rolls-Royce cabinets, computers, sports coats, carpet cleaners. The idea, the assumption, the belief, the faith of dilution law is that if you have Rolls-Royce in these other realms, and there is no actual confusion or no actual likelihood of confusion, that Rolls-Royce in some way is the source or sponsor or licensor of the mark in these other realms, there is nonetheless the possibility that it will be that much harder for Rolls-Royce to perform its trademark function in the car context. How does this translate to consumer harm, right? I mean, maybe, or at least the theory for some, is that this may in some way increase consumer search costs. And the restatement says, there's a dissonance that occurs in the consumer mind if you have these other kinds of uses of the trademark term that may blur the stimulant effect of the mark. And Judge Posner in the Thai Incorporated case says, kind of posits this hypothetical. Suppose you have an upscale restaurant that calls itself Tiffany, and there's no risk of confusion with a jewelry store. But when consumers next see the name Tiffany, they may think about both the restaurant and the jewelry store. And if so, the efficacy of the name as an identifier of the source will be diminished. Consumers will have to think harder, incur, as it were, a higher imagination cost to recognize the name as the name of the store. And so do you find this persuasive? Is this a meaningful harm, or is it somewhat hypothetical? What exactly do we think is going on with blurring? As we kind of have three issues we could disaggregate here. What is it that strong marks do in the first place? What exactly is their selling power beyond the goodwill they build with consumers? And then what is the harm that dilution by blurring targets? And does blurring activities, or activities that are actionable under the statute, do they actually cause that harm? And so how might we think about this, by way of hypothetical? So suppose I want a cup of coffee and I'm out and about and I'm in the mood for a store-bought cup of coffee. And so what exactly is going on in my mind? So one possible role of a strong mark is that, in my brain space, there's any number of coffee brands, coffee sources, coffee this, coffee that. But, one thing that may loom larger than the others, perhaps, is the famous Starbucks brand. And so there's a certain selling power in my mind built on the fame, the power, the what have you of Starbucks. But what exactly does that translate to in practice? What exactly do I do that's different because of the power of the Starbucks brand, right? Do I go looking for Starbucks? I mean, if I go looking for Starbucks, maybe it's because I like it, right? And if I like it, if I already have brand loyalty to it, maybe, it's pretty resistant to dilution, right? Or maybe I Google Starbucks instead of Googling coffee shop. Or maybe I'm somehow primed to choose Starbucks, right? If I have divided attention at the moment and I don't want to think too hard about where to go for coffee and just, Starbucks, right? Because it comes to mind. Maybe I'm more likely to notice Starbucks among, various coffee shop options. Maybe I go to Starbucks without thinking about it, right? It's a kind of cognitive shortcut. And again, are these cognitive shortcuts actually salutary for me as a consumer? Do I actually gain from that? Or is that some kind of unearned benefit on the part of Starbucks? Or maybe something else goes on. And so in these various possibilities, we might query which of these possibilities could be said to benefit me as a consumer rather than Starbucks as a brand, right? And of course, maybe we want to benefit Starbucks as a brand, but we usually try to have some kind of theory that is congruent with the interests of the consumer when we talk about this in trademark laws. At the very least, it's helpful to have that kind of thing. And then, of course, we have this important caveat, right? Does this actually apply to consumers with preferences? So in my mind space, Starbucks, has a prominent place as something that I know and recognize and I talk about because I teach trademark law, but it's not something that plays a big role for me in thinking about where I might go for coffee because I don't particularly like Starbucks. And if you were to imagine, the size of brands in my brain based on where I might actually like to get coffee, Dunkin Donuts plays a much greater part in my brain space than Starbucks.
You want to talk real customers? Kid, that's me. I'm like the mayor of Dunkin's. This is the face of Dunkin Donuts right there.
Hey, you can't smoke in here, man.
I'm not, Mark. I'm not smoking
You're
in here.
smoking in here.
Yeah, I come down to Dunkin' every day. Grab a cruller, have an extra large, 3 parliaments, take a big dump. That's kind of the routine.
And then, even, more than that, my local coffee shop that isn't a chain at all, but just happens to be the one down my street and the one that I would go to if I want to have a cup of coffee near my house. So even if we have a story about how famous marks may have some kind of boost in the consumer mind, query whether this applies to consumers who have actual preferences. But even if we buy this theory, we have to ask, is this good for consumers, and what search costs, if any, are minimized by having this kind of fame perform a role, whatever function it does perform, in the marketplace. And then we get to the actual harm of blurring, or what we think may be the harm of blurring. And so what does blurring do, right? The idea is that Starbucks doesn't loom so large in the imagination of the consumer, right? It's harder for the consumer to summon the name Starbucks. And now Starbucks is more on par with Dunkin Donuts, with Intelligentsia, with the local coffee shop, with the unknown coffee shop, with the local chain, et cetera, et cetera, et cetera. And so as we've asked in other parts of this course, maybe that kind of lessening of the trademark's power could ultimately be a good thing for consumers, insofar as perhaps the conditioned association does not necessarily lead to the optimal purchase for the consumer, right? The shortcut is not always going to be optimal in terms of consumer outcomes. And then we have this other question about whether or not this actually happens in real life. That insofar as there's some selling power that can be traced to the marks being famous, whether or not so-called blurring activities actually counteract that fame. And so we can think about any number of examples where we have marks that are very well known that are just happen to be diluted by, in the trademark sense, by their use in other contexts. So think about airlines. A very well-known airline is Delta, and it certainly would seem to qualify as a strong mark in the airline space. And it does so notwithstanding the existence of Delta Faucets, which is a well-known brand for, faucets. There are Delta Faucets, there's Delta Airlines. Neither company has seen fit to change their trademark because it seems like they're doing just fine with the marks as they are. Likewise, you can think about any number of strong trademarks that have the word American in their name. American Airlines, most prominently, American Eagle Outfitters, American Apparel, American Express, the American Broadcasting Company, ABC, the American League in baseball, right? Why are all these companies putting up with having American in their name if they're being diluted by everyone else who has American in their name, and yet they're doing just fine? And then query whether or not, to the extent that we still buy the story, whether trademark uses are especially likely to dilute, right? Because is it worse to have, American for American Airlines? Is it worse that there's an American League, American Broadcasting Company, American Apparel, American Eagle, American Express, than everything else that uses the term American? The Americans TV show, George Clooney's film, The American Gothic, the painting, American, anything pertaining to the United States that gets associated with American, right? And so there's all this dilution going on, but it doesn't seem to matter. American is still a pretty powerful mark, and it doesn't seem to matter. You type in American into a Google search, and your first hit is American Airlines. And so if American can survive these kinds of activities, why can't other famous marks? Do we have any confidence that this kind of thing is going on? And so there's an excellent review of the literature by Rebecca Tushnet in an article called Gone in 60 Milliseconds, Trademark Law and Cognitive Science, that kind of sorts through some of the empirical work that's been done that purports to justify the dilution cause of action. And it gives a really good critical analysis of a lot of that. So if you're interested in some of the research in this area, it's a really good article. And her conclusion is just basically, given the available evidence, the cognitive model of dilution lacks empirical support to justify its adoption as a general theory underlying dilution law. There's still too much we do not know about how consumers process marks in the marketplace. At a minimum, we cannot predict that any particular dilutive use will produce the difficulties posited by the cognitive model. And then the other problem, tied to all of this is that the dilution cause of action is potentially broad. I mean, after all, any kind of use of a term may potentially be said to potentially whittle the power of a mark. And so isn't it equally possible, though, that non-confusing uses of marks may actually enhance the distinctiveness of a mark, right? By maybe reminding consumers of the existence of the more famous brands. So, the theory of dilution law is sort of, this idea of, when you have all these other uses of a trademark term, it becomes like a death by 1,000 cuts. But, maybe not. Maybe if every time you see a famous mark in some other context, you're reminded of the original usage, or the more famous usage. And maybe instead of being a death by 1,000 cuts, it's life by 1,000 little hugs. The other thing that to kind of keep in mind as we work through some issues in dilution law is the possibility that maybe trademark law has outgrown the idea. So when Schechter was writing, the scope of the trademark cause of action was considerably narrower than it is today. And as we've discussed, of course, the trademark cause of action reaches now far beyond what it used to 100 years ago. Query whether or not trademark law maybe has outgrown the idea that to whatever extent we think there is a danger of certain kinds of uses that are not confusing, but may still potentially weaken the ability of a mark to identify and distinguish a good in the marketplace. Those kinds of uses are already covered by the capacious cause of action we have that reaches things like non-competing uses of a mark that may confuse as to source, as well as sponsorship, and at extremes, things like approval and confusion that may be dispelled before the point of sale, pre-sale confusion or so-called initial interest confusion, or may even reach potential confusion after the point of sale by third parties. And given how broad trademark law has gotten, maybe dilution is an idea that, perhaps made more sense when it was first posited in an era of more restrictive trademark law than we have today.